Ms. Finis.
You are the next people to speak to their submissions are from the Victim Support Service. I could ask them to come forward. Good afternoon. Perhaps if I can ask you to identify yourself first, Ms Sloan.
Yes. Hello, I'm Jodie Sloan. I'm the Program Manager and Deputy Chief Executive of Victim Support Service in South Australia.
Thank you.
Hello, and I'm Jack Taylor. I am the Coordinator of Counselling Services and Royal Commission Support Services at Victim Support Service in South Australia.
Thank you. What services do the Victim Support Service offer in South Australia?
Yes, I'd like to be able to talk about that in my statement,
Certainly.
if possible.
Yes, certainly. I invite you to speak to your submission.
Thank you. On behalf of Victim Support Service, I'd like to thank the Royal Commission for the opportunity to present at this public hearing. I'd like to commence by speaking briefly about Victim Support Service and then highlight some of the recommendations that we made in our submission. Victim Support Service is an organisation that was formed by victims of crime for victims of crime. We have been the lead agency in South Australia for victims of crime since 1979. We are a statewide South Australian non-government organisation which provides free support, counselling and information services for adult victims and survivors of crime. We are not affiliated with any religious organisation. Since 1979, we have been advocates for victims' rights. We deliver programs that focus on victim engagement and evidence-based practice in areas such as trauma, crime prevention, homicide, domestic violence and child sexual abuse, and are one of the DSS-funded Royal Commission support services. We are a service that has a history of advocating for greater participation of survivors of crime in the criminal justice system, for their voices to be heard through processes such as victim impact statements and their right to access victims of crime compensation. We have supported many individuals over many years to access various redress schemes for adult survivors of childhood sexual abuse. As such, we believe we have a well-developed and thorough understanding of how these processes and outcomes are experienced by individuals. We presented 23 recommendations to the Royal Commission in our submission on redress and civil litigation, and obviously we don't have time to speak to all of those recommendations, but today we would like to highlight what we consider are some of our key points. Firstly, like many who've already spoken today, we strongly endorse a national redress scheme for both past and future abuse survivors. We believe that a national redress scheme needs to be complex trauma-informed and survivor-driven, underpinned by a national legislative framework to ensure consistency, and should be administered by state and territory governments. Importantly, we would like to highlight that a national redress scheme must be about more than financial compensation, and we endorse the principles for counselling and psychological care as outlined in the consultation paper. However, we recommend that there should be no requirement for a DSM-5 diagnosis to access the redress scheme. Associated support services such as counselling or Medicare-funded services such as mental health care plans. We would like to emphasise the importance of trauma-informed counselling and support models that are based on an understanding of complex trauma and focus on survivors being able to connect and reconnect in and out of support services at different times of their lives, and that a survivor's right to do so should not be dependent on a DSM-5 diagnosis of a mental disorder. We wish to highlight our concern about the need for consistent ongoing counselling, legal and support services for survivors at the completion of this Royal Commission. We would like to see the expertise and experience that has been developed by many services continue, and by this we mean service providers not only having an understanding of the effects and impacts of child sexual abuse, but also the knowledge and understanding of the impact of institutional life and abuse. I'd now like to comment on our position regarding the funding of a national redress scheme. Victim Support Service proposes that the liability for child sexual abuse exists beyond the perpetrator of the crime. The perpetrator has the primary liability for the crime committed, but institutions and systems that allow the perpetrator access and cover for the abuse also have a level of liability for the abuse. As such, we propose a three-tiered funding model for a national redress scheme. We submit that the primary responsibility for child sexual abuse lies with the perpetrator and that perpetrators should be liable for compensation paid to their victims. With this in mind, where there has been a criminal conviction, the assets of the perpetrator should be seized and either a direct monetary payment made to the victim or the assets should be allocated to the National Redress Scheme funding pool. We believe institutions need to be made responsible for abuse that occurred within their organisations, and that all institutions where child sexual abuse has taken place should be required to pay a mandatory contribution to the National Redress Scheme. This could be on a sliding scale, with all institutions required to pay a base percentage into the scheme, plus additional contributions based on the amount and severity of the failings of the institution. This structure would ensure that all victims could benefit, including those who were abused in institutions that no longer exist or retain assets. With regard to institutions that no longer exist, if the institution has been rebranded, merged with another institution, dissolved and reformed with the same people, or in some way a current institution has a tangible and traceable connection to an institution where abuse took place, we believe the current institution should be held partially liable for the previous institution's failings. The extent to which this liability would extend would depend on the level of connection to the previous institution and would have to be assessed on a case-by-case basis. In South Australia, each fine imposed and conviction recorded requires the offender to pay a levy into a victim of crime compensation fund. This fund contributes to fund compensation for victims of crime and also fund victims of crime support services such as Victim Support Service. If similar victim of crime compensation funding approaches were implemented by all states and territories, victim of crime compensation schemes could partially fund a national redress scheme for survivors of institutional child sexual abuse. A portion of the victim of crime compensation fund in each state could be diverted to fund the national redress scheme, ensuring that all who breach the laws of Australia contribute to the ongoing care and compensation of survivors of institutional abuse. Finally, just some brief comments regarding civil litigation. It's fair to say that the majority of survivors that we have worked with have not pursued civil litigation, as they deem this as too difficult and too traumatic. Some have begun this process but have been unable to continue due to the many obstacles in our current law. Of the small minority who have pursued this, they describe it as a long, horrendous process that is re-traumatising and victim-blaming. Overwhelmingly, they express that this process has impeded their recovery, leaving them feeling simply violated as they were by the original abuse. We believe that civil litigation must continue to be an option for survivors. However, eligibility and procedures need to change in recognition of the ongoing effects of child sexual abuse in an institutional context, such as the length of time it may take for a survivor to disclose. We strongly support that all statutes of limitation in relation to sexual abuse are abolished and abolished retrospectively. We recommend that there is retrospective legislative reform to enable the identification of a proper defendant. We endorse the option for reform whereby a statutory property trust is a proper defendant where no more appropriate defendant can be found. We submit that it is appropriate to impose a duty upon institutions and that the lack of statutory duty on institutions is prejudicing victims in the civil system, as their claims are being judged by the standards of the time in which the abuse occurred. Standards that today are universally accepted to be inadequate. For example, a recent South Australian case against Prince Alfred College saw an adult survivor denied compensation based on the standards of the 1960s. We recommend that a retrospective duty be imposed on institutions unless the institution took reasonable precautions to prevent the abuse. In addition, we recommend that a separate and higher standard be imposed prospectively, which will require institutions to take significant precautions to prevent abuse and fulfil their duty of care. Finally, we encourage collaboration between insurance companies and the Royal Commission to develop an outline of minimum precautions that insurance companies would require to insure an institution, which would be the basis for significant legal precaution.
Thank you, Ms. Sloan.
Thank you.
Ms. Sloan, can I take up with you the question of civil liability? And I've read Justice Vanstone's judgment, and I'm grateful for you providing it to us. Has there been an appeal from that judgment?
It's my understanding there is an appeal, yes.
It's on foot, is it?
Yes, that's mine. Yes.
Sorry?
Yes, I believe there is an appeal currently.
It hasn't been determined, I assume?
No.
When you say that the judgment reflects the application of the standards of the 1960s, what is it that you have in mind?
I'm going to defer to my colleague for this response.
Please.
My understanding of having read the case, and I'm not a lawyer, I'm a social worker, so I'm hoping I've got this correct, is that whilst the college dismissed the teacher in question, they did not report to police. And so it's about what was considered, what, from my understanding, was that an acceptable thing to do back then, recognising that, it wasn't routine back then to have things such as police checks, etc., with employment. But child sexual abuse has always been a crime, and they did not report to police. So, and that's not the only issue, I believe, in that, but that's certainly something we drew out of that. And I think, from my understanding, Her Honour was saying that, how the college responded was in keeping with what happened at that time. We would be saying the impact of that, to judge that now in regards to a survivor's right to redress and to some sort of compensation for the harm done, is deeply problematic because it rules that out. And the harm, I suppose for us the reality was that it was found in that case, and this is what struck us, it was found that the abuse took place. I mean, it's clearly in the case that there was a conviction. He was abused, he experienced, he was diagnosed with PTSD. It was also found by Her Honour that the impact on his life had been extremely devastating, and that was causal back to the abuse. But it got nowhere. So his life was irrevocably harmed by the institutional abuse, but due to our current law, he was not able to get justice through the court system.
What I think you're focusing on is the common law in Australia, which says that the institution doesn't carry an absolute liability through whatever mechanism, for abuse which occurs within its environs. And I infer that what you're suggesting is that when it's a school that's involved, and this was a boarding school as I understand it,
yes,
then the school should carry that liability, even if it didn't authorise the teacher to commit the illegal act. Is that what you're, what you're saying?
Partial liability, yes.
I'm sorry?
Partial liability.
Well, I was going to take you up on that too. What do you mean by partial liability when you speak of it?
I guess, Your Honour, we're saying that the institution has a responsibility around the employment of staff, the development of some policies and procedures around how to respond to disclosures of child sexual abuse. Clearly, a policy around the reporting of crime to police. So that they have a duty of care. We see that as being partially liable for not enforcing their duty of care.
So you see it in terms of an institution, school or otherwise, having enforced against it in the civil damages context the obligation to fulfil a duty of care with a defined content for that duty. Is that what you're thinking?
Yes. Yes.
But you're not saying, as I understand it, that merely because it's a school which has borders, that without more the school should be liable. You're not, as I understand, you're not suggesting that.
Sorry, Your Honour, I'm not quite sure I've understood what you've said.
You see, you could say this is a boarding school. There's a boy here who's a boarder, and he's abused by a teacher at the school. Irrespective of whether the school had good procedures or bad procedures, the school should be liable if a child in its care is damaged. But I don't understand you to be saying that.
No.
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 Just to assist that, I understand in your submission just then that you talked about where a institution takes reasonable precautions to prevent the child sexual abuse, that should be taken into account. And so in terms, it's on absolute liability. It's a liability that comes into play if those precautions are not taken. Is that correct?
That's correct.
And that's referring back to the what was in the consultation paper in regards to absolute, reasonable, but then in regards to prospective, we've introduced the idea of significant because with what we know from this Royal Commission, it seemed reasonable to us that we need to be better protecting children. So we raised the bar for prospective.
Can I just ask this question in relation to perpetrators? You've indicated, I think you're one of the very few submissions that have indicated that the perpetrator should in fact contribute directly either to the fund itself or to the victim. In many of the institutions, we're led to the belief that the perpetrator themselves have limited assets or no assets at all, particularly in some of the religious institutions. Is it your experience in South Australia, given you have a wide remit in relation to the criminal justice system, that perpetrators do in fact make those contributions that you've spoken of?
Yes, I believe they don't have a choice about making that contribution. I understand that Crown Solicitor will be speaking on behalf of government in this public hearing, and he may be, I'm sure, able to talk to that better than we can. But we understand that whilst not all perpetrators may have the financial means, may have those assets to be able to be that can be seized, there is a process there to attempt to do that for all perpetrators. That's my understanding. And so I think it's an important process for survivors, knowing that process will be followed through by the government to attempt to seize any assets the perpetrator may have. If that's not possible, then so be it. Then we have a victim of crime compensation that is a scheme of last resort.
Is it the case that if there are no assets held by the perpetrator, the amount that should be contributed by the institution in which the abuse occurred should increase to compensate the lack of assets for the perpetrator?
Again, I think that's a very good question, and I think we talked quite generally about a sliding scale, and that would need to be a case-by-case decision. I think, again, dependent on the role that the institution has played in not speaking out about that abuse or acting inappropriately and conspiring conspiring with the perpetrator, maybe yes, they should be required to pay more into that.
Can I just understand this confiscation of assets arrangement? Are all their assets confiscated, or are they just confiscated to the extent of providing victims of crime compensation?
I believe, and again I will need to defer to our Crown Solicitor, but I believe that it is assets in order to be able to contribute into the Victims of Crime Compensation Fund.
Right. To the extent of the payout to the victim.
Yes,
that might be subsequent. And that, I assume, places no restriction on the victim suing the perpetrator in the ordinary courts for damages.
No, that's right.
Yeah.
Yes.
Thank you, Your Honour.
Yes, thank you both, and thank you again also for your contribution throughout our deliberations.
Thank you.
Thanks for coming today.
Thank you.
Thank you.